Chapter 9, Workers' Compensation. The learning objectives for workers' compensation are 1. Define key terms. 2. Discuss the histories of workers' compensation, including statutes and reform. 3. State the purposes of workers' compensation laws. 4. Discuss workers' compensation program funding and the ways that premiums may be purchased by an employer. 5. Define and discuss second injury fund. 6. Specify who is eligible for insurance coverage under federal workers' compensation laws. 7. Name persons entitled to be insured under state workers' compensation laws. 8. Determine the waiting period in each state before benefits begin. 9. Describe the types of compensation benefits. 10. Define non-disability, temporary disability, and permanent disability claims. 11. List signs of fraud and abuse involving employees, employers, insurers, medical providers, and lawyers. And 12. State when to report fraud or abuse involving a workers' compensation claim. 13. Explain 2 ways in which depositions are used. 14. Explain the advantages of filing a lien. 15. Define and discuss third-party subrogation. 16. Describe workers' compensation health and financial record keeping in the medical practice. 17. Explain the procedure of completing the doctor's first report. 18. Name the contents of a progress of supplemental medical report. 19. Complete workers' compensation forms properly and discuss fee schedules. 20. Discuss electronic claim submission and explain how to handle out-of-state claims. And 21. Describe actions to take in following up on delinquent workers' compensation claims. The history. Before workers' compensation programs, workers had to prove legally that injury was caused by work-related negligence. Workers' compensation enabled injured employees to receive medical care without going to court. Under workers' compensation laws, a physician who is incorporated is considered an employee. The first workers' compensation laws were enacted in 1911. Today, all states have workers' compensation laws, and workers' compensation is the most important coverage written to insure industrial accidents. Workers' compensation statutes. The laws vary state by state. The statutes relieve the employer of liability except for gross negligence. Statutes allow employees to be more easily and quickly compensated for lost wages, medical expenses, and disability. Federal compensation law applies to the miners, the maritime workers, and government workers. State compensation laws apply to the employees and employers within each state. Workers' compensation reform. By the 1990s, legal and medical corruption and abuse resulted in record high levels of expenses for compensation of healthcare professionals, legal expenses, and other costs. Reform laws made it easier to prosecute system abusers such as the physicians, the lawyers, or the employees. Laws placed greater emphasis on occupational safety to proactively prevent costly injuries. Laws address the systematic abuse and fraud. The laws vary from state to state, and some of the issues could include proof of medical necessity, pre-authorization of treatment, the medical bill review, caps on vocational rehabilitation, and the use of mediators. Purpose of workers' compensation laws. There has been a greater emphasis on workplace safety and preventable accidents because proactively implementing safety measures is the most cost-effective for the employer and society at large than treating the resultant injuries. The purpose is to provide best available medical care to the injured, to ensure maximum recovery, provide income to the injured regardless of fault, reduce overall expenses, resolution time, and litigation, encourage employer workplace safety, and promote study of workplace accidents and hazards, and then facilitate the improvements. Self-insurance. They're a company that pays for medical expenses instead of insurance premiums. The self-insured companies tend to be those with good safety records and/or few workplace hazards. The employee is covered by ERISA, which is the Employee Retirement Income Security Act. Reinsurance, stop-loss provisions, and captive insurance plans administered by outside firms may all result in delay of claim payments if not pursued aggressively and knowledgeably. Because of the health reform in 2010, companies that offer health plans must allow their employees to keep their children on their plans until they are 26 years old. With the passing of the Patient Protection and Affordable Care Act and the Health Care and Education Reconciliation Act of 2010, beginning in 2014, almost everyone is required to be insured or they will pay a fine. Large employers with more than 50 employees must pay $2,000 per employee per excluding the first 30 employees from the assessment if the government subsidizes their work coverage. Managed care. Managed care contracts use fee schedule-based payments, require pre-certification for certain procedures, implement hospital and medical bill review, and a corporate utilization review of medical services. There's an increased number of employers are seeking managed care contracts with preferred provider organizations, the PPOs, and health maintenance organizations, the HMOs, to insure their workers against industrial accidents and illnesses. Managed care contracts are not uniform and may limit the choice of providers. Eligibility is for private business, state, federal employees are entitled to workers' compensation coverage. A workplace accident that results in injury is covered. Illness or disease that results from environmental factors in the workplace is covered. And workers' compensation will also cover injuries that occur while working, even if not at the company's site or during travel to and from a business meeting or anywhere else that requires travel. Coverage. Federal laws. Employees who work for federal agencies are covered by a number of federal workers' compensation laws. These programs are provided through an exclusive funding system and are administered through the Office of Workers' Compensation Programs, the OWCP. They are government employees such as postal workers and FBI agents, workers in Washington, D.C., coal miners, maritime workers such as longshoremen and harbor workers. Each of these groups are governed by specific laws and acts. State laws. The provisions cover workers not covered by federal laws. The employer must purchase workers' compensation insurance from private companies or be self-insured with adequate cash reserves. The employer must also have employer's liability insurance. The employer must report a work-related accident if required by state law. Penalties vary from state to state. The employer's liability insurance protects against claims for bodily injury to non-employees or damage to their property. If an employee slips and falls in the employee bathroom, does workers' compensation apply if the worker is injured? And absolutely yes, because it did occur during work time. If a customer slips and falls in the parking lot, does liability insurance apply for any incurred injuries? And that would also be yes. The employer's liability would apply. Every state requires children who are injured on the job to be entitled to the same workers' compensation benefits as other injured workers. However, most states provide additional workers' compensation protection over and above the standard workers' compensation benefits paid to adults. Questions may arise as to which state's law determines payment of compensation benefits if a worker's occupation takes him or her into another state. For example, a truck driver. Most compensation laws are extraterritorial, which means they are effective outside the state by either specific provisions or court decisions. When billing, follow the rules and fee schedule of the state in which the workers' compensation claim was originally filed. Provides coverage for civil defense and other volunteer workers, such as firefighters and paramedics. Employer and physician requirements for filing injury reports vary by state and territory. Second Injury Fund, Subsequent Injury Fund, SIF. This fund covers employees with previous injuries or conditions who was injured on the job. It encourages hiring of the physically handicapped and allocates benefit costs more equitably. The minimum number of employees varies by state and territory. Some occupations are exempted, and there are no waiting periods for workers' compensation to pay for medical bills resulting from a workplace injury or illness. However, each state has defined the waiting period, which is required for the injured employee to receive wage benefits. The waiting period is defined as the number of days an employee must be unable to work as a result of a workplace injury or illness before income benefits are payable. Benefits. Medical treatment includes hospitalization, medication, prosthetic devices, if indicated. Temporary disability indemnity. This is in the form of weekly cash payments for lost wages made directly to the injured or ill person. Permanent disability indemnity. This may consist of either weekly or monthly cash payments for lost wages based on a rating system that determines the percentage of PD or a lump sum award. The payment amount depends on how much the individual earned before the injury or illness, has typically capped at 2/3 of their wages. Death benefit for survivors. This consists of cash payments to dependents of employees who are fatally injured. A burial allowance is also given in some states. The rehabilitation benefits can be medical or vocational for disabilities. Types of state claims. Non-disability is a minor injury that requires medical attention, but the employee is still able to work. Temporary disability is the employee is unable to perform work duties for a specific time period. The goal is to maximize function as quickly as possible and allow the employee to return to work or modified work. Permanent disability is the worker is unable to return to the previous occupation because of a residual disability. The physician's final report must state permanent and stationary, meaning that no further improvement is expected. Then a settlement or compromise and a release is reached between the injured party and the insurer for a total sum, and the case is closed. And the final determination of the issues involving settlement of a work-related accident is known as adjudication or the rating of a case. Fraud and abuse. Physicians are responsible for determining legitimacy of work injuries and accurately reporting findings. All individuals who deal with workers' compensation cases must report suspicious situations to the insurance carrier. If the claim is knowingly fraudulent, fines may be imposed. licenses may be revoked, and imprisonment may result. Actions can be taken to have the case investigated further by personnel from the fraud divisions or referred to the district attorney's office. Healthcare professionals, clerical staff, and any others involved in workers' compensation cases are responsible for reporting potential abuse and fraud. Occupational Safety and Health Administration Act of 1970. This act protects employees against workplace health and safety hazards. Complaint procedure enables individuals to pursue enforcement measures in their workplace. Non-compliance with work standards by employers can result in fines. It applies to most businesses and applies to the heavy, light, and service industries, the nonprofit organizations, churches, hospitals, and retailers. The organizations that are not affected by OSHA is it doesn't apply to the federal employees, farmers' families, church employees engaged in religious activities, the independent contractors, or household domestic workers. Legal situations. A medical evaluator is a physician who conducts medical and legal evaluations of injured workers. They must first pass a special medical exam for certification by the Industrial Medical Council. They're hired by an insurance company or appointed by appeals board, and they conduct unbiased assessments of disabilities. Depositions and medical testimony. They discover additional facts from the physician, patient, or other party about the case. The proceedings take place under oath, but not in open court. Findings may be used to impeach, which is challenge credibility, a witness on cross-examination. Findings may be used when case comes to trial. The physician should be compensated for the time spent preparing to be an expert witness. All agreements should be signed by the physician and lawyer. Sessions are recorded by stenographer, shorthand, audio tape, or videotape, depending on the circumstances. Sessions can be conducted in the attorney's office, physician's office, or another location. Liens express the legal claim on the property of another for the payment of a debt. Null and void at the end of a specified time limit. Subsequent or amended liens can be filed, and they should be signed by the patient and/or employee and the patient's attorney. The physician's fee should be protected by having the attorney sign the lien and indicating that the physician will be paid directly from any money received in the settlement. The advantages is court recognizes written agreements, provides protection in event of litigation, it ensures payment for medical services, provides inexpensive means to collect full fees, judge determines if fees are reasonable when amount billed is more than the allowed amount, and it helps avoid problems with collectors. Payment may not be received for a long time, but a lien ensures that if there is a settlement, the physician will be paid. Third-party subrogation transfers claims from workers' compensation insurance carrier to third-party liability carriers. It's used in events such as auto accidents where another party may be liable for the claims. A subrogated carrier has legal claim to reimbursement of expenses. Medical reports. Health information record keeping. You want to maintain a separate medical record. Maintain a separate financial ledger. Keep appointments for occupational injury or illnesses separate from unrelated matters. Keep documentation or dictation for each appointment separate. Keep only records of exams and treatments that pertain to the occupational injury or illness in the special file. And enter only billing statements that pertain to the occupational injury or illness and that will be sent to the workers' compensation in the separate ledger. Terminology. Most workers' compensation cases involve accidents causing bodily injury. Become familiar with the anatomical terms, directional and range of motion words. Types of fractures. Fractures can occur from falling, blows, impact hits, a disease process, or direct violence, such as a car accident. Body activity terms, and words that describe pain and symptoms. Healing may take months and depends on the location and the severity of the injured part, associated injuries, and complications or infections. Reporting requirements. The employer's report is required by law in most states. Time limits for filing of employer report vary from state to state. Copy of the medical service order should be retained for treating doctors' files. Written authorizations with valid signature is always preferred. An outside testing or treatment must be pre-authorized by the workers' compensation insurance company with name and title of the person authorizing the service. The physician's first report. The physician must complete a standard form or a narrative letter after the first exam of the employee. Every copy must be signed in ink by the physician. The original is sent to the insurance carrier. Copies are sent to the state agency, the patient's employer, and also one in the physician's file. Progress or supplemental report. The supplemental report is sent to the insurance carrier after 2 to 4 weeks of treatment to note current status. The progress report is sent to the insurance carrier if there is significant change in prognosis of status. All reports should be copied in the patient's workers' compensation chart for the physician's file. Claim submission. Financial responsibility. No copays or deductibles are collected from the injured employee in a workers' compensation case. Workers' compensation insurance is billed for all expenses. The physician agrees to accept payment according to the carrier's fee schedule. Patient's health insurance information should also be obtained and filed in case of a non-related medical expense. A non-related medical expense could be an example of high blood pressure. In this case, the portion of the exam becomes a financial obligation of the patient or the patient's private insurance plan. Fee schedules may follow special workers' compensation or Medicare fee schedules. Some include maximum reimbursement amounts, which may be exceeded and covered in certain situations, such as special training or qualifications and usual fees. Additional documentation by the physician may be needed. The employer, the state agency, or the insurance carrier or payer may audit or review the fees. The electronic claim submission and reports. Electronically submitted workers' compensation claims and data must comply with state insurance regulations. Carriers may have separate claim forms for workers' comp, not the CMS 1500, and the electronic system or telephone submissions. Out-of-state claims. They follow regulations for state in which the injured worker was hired. They obtained and follow out-of-state fee schedules for billing purposes. Companies whose employees routinely travel to other states usually require employees to have workers' compensation insurance in those states. Delinquent or slow pay claims. Phone the patient's employer to verify information. Send copy of claim form and itemized account statement to the carrier. Phone insurance carrier out to 45 days and request expected date of payment. Send the employer a copy of the financial account statement with the outstanding balance. Contact the state board if employer fails to file the employer's report of work injury. And this completes the lecture of Chapter 9, Workers' Compensation.